Good morning and welcome to our second day of the January docket. I'd like to begin by introducing the panel that you have today. To my right is Judge Tim Easter from Williamson County, and to my left is Judge Jill Ayers from Montgomery-Davidson County. I'm Bobby Holloway from Murray County. And I'm sure most of you know each side has 20 minutes. If you want some rebuttal as the appellant, please let us know at the beginning. Any preliminary matters?
No, Your Honor.
Also, as you probably know, we've read the briefs. Typically, we haven't read the record yet, so there may be some things come up that we haven't read. All right, call the first case, please.
State of Tennessee versus Steve F. Mabe, Jr.
Good morning, Your Honors. Daniel Turkley, Wilson County Bar, represent Mr. Steve Mabe, the appellant. Would request to reserve 5 minutes for rebuttal, please.
All right.
Your Honors, this is a case about a man and a dog. That was the beginning of the opening argument in this case that I made in this case, and that was the way that this case should have started and the way it should have stopped. Essentially, a woman in Brush Creek at 18 Brush Hollow Pike called the police for assistance for a man on her property petting her dog. That was all that happened on this property. Police come to investigate. They admit on the stand, Your Honors, that there was no evidence of any kind of break-in, no evidence of any kind of theft, no evidence of any kind of crime other than this man being on her property and petting her dog. She suspected he was there to go into her car. No evidence anything was ever intended, or for sure nothing ever happened like that. This is about 10:30 at night. And to investigate this trespass, officers go to a neighboring property, knock on the door, talk to a neighbor, get no response. They go to another property where they encounter a red Jeep that made them believe that may be connected to the crime, because the woman said that maybe a ATV had driven off after the man had left. Jeep pulls off onto the property at 32 Ward Hollow. Officers go into the property past fencing, past no trespassing sign, to confront the individuals in this Jeep. And this is the first of 3 unconstitutional intrusions into this property. The officers testify, Officer Campbell testifies that they go into the property, confront the Jeep in the dead of night. They have not identified themselves. There is no flashing lights on the street. Let them know that there are officers on the property. Reaches down to his waistband, grabs his flashlight, points it, activates it, and as soon as he activates it, a shot comes flying back at him. A single shot. They immediately hit the deck. They hear that they describe that a herd of elephants goes running in the opposite direction. They have no idea who took the single shot, what the reason for that shot was, other than the fact they were there and pointed this flashlight and activated it. They retreat back to the street. They call for backup. The radios are not working inside the property. In the interim, Your Honors, they flood the field with light and order the occupants of this Jeep to come out. 2 individuals come out by the names of Davidson and Spurlock. They come out of the property. They're not searched. They're not processed, but they come out. 30 to 45 minutes later, after the officers have retreated, the SRT team arrives onto the property. Presumably, the officers would have had time at this point to get a warrant to go into this property to search for whoever they were looking for, but they chose not to do that.
Let me ask you, did Davidson, Spurlock, or Mr. Mabe have an ownership interest in the property?
Mr. Mabe was a resident at the property. He did not own the property. His girlfriend, Miss Hale, was an owner of the property. Spurlock and Davidson did not have any ownership or residential interest whatsoever. Mabe did live at the property. The record does reflect that. I'm sorry, Your Honor.
Yeah, that's good.
Where was I at? Oh yes. So the officers had retreated 30 to 45 minutes after they retreated from the property. SRT team shows up. They make another incursion into the property to go and search for whoever this individual is as part of this, again, self-described herd of elephants that ran away in the other direction. They passed by vehicles that are on the property that Mr. Mabe personally maintained. They were walking down a driveway that was basically a homemade driveway on this property. They eventually encounter a house. At that house, they believe it to be occupied. They call for the occupants to come out. Nobody comes out. They then breach that house, send in a robot to go and check for an individual. They find nobody. They then breach it manually, go in and find Miss Hale under the bed with two rifles, I believe. So now they've gone onto the property to investigate this trespass. They've come back out. They've gone back on with the SRT team. That makes 2. They go into the house itself. No warrant. That makes 3. As they're pulling Miss Hale out of the house, she yells spontaneously, "Run, run, baby, run." No indication as to who she would be yelling to, but clearly she's telling somebody to get away. Officers then go further into the property, and this causes a hours-long manhunt where they eventually find Mr. Mabe hiding, admittedly, in a marijuana patch on the field or on the property. The issues, Your Honor, is they had no idea, no description of who they're looking for, no identity of who they're looking for. They were apparently intending to clear this property of all human life until they found every single person that might be on it, with no probable cause to go onto the property in the first place.
They had been shot at from this property, correctly? Isn't that exigent circumstances to allow them to enter on the property?
Judge, in a vacuum, the shot could be exigent circumstances. However, under the circumstances, there wasn't even a certainty that a crime had been committed when that shot was fired.
There was what? I'm sorry.
Your Honor, what I'm saying is there wasn't even certainty that a crime had been committed when that shot was fired. I mean, and what I'm saying, to be clear, is that shot being fired itself was not necessarily criminal. The facts, totality of the circumstances being that officers go onto this property without identifying themselves. There's no proof in the record that these people had any idea who these officers were. They had not identified themselves until after the shot comes out. Then they tell everybody to come out with their hands up. They retreat back to the property. The officers testified, Officer Gregory testifies, that these individuals could have reasonably believed that the officers, were there to burglarize the place. So it's kind of an interesting duopoly where they're investigating this trespass on one property, and they themselves reasonably could appear through their own admission to have been burglarizing that property that they were now at. So the shot itself could have been reasonably justified. But even if we set that aside and take the exigent circumstances for what they are at face value.
And wasn't that conceded at the trial level, that the gunshot did create exigent circumstances?
Judge, the state argues that in their brief, and when I saw that there was a concession in the brief, or that was being argued in the brief, I kind of panicked, because this was a knockdown, drag-out trial. There was no air of concession whatsoever. When I figured out what it was in the suppression hearing itself. Previous counsel, Mr. Whitaker, who, by the way, did a fantastic job in that suppression hearing, he was making an argument, basically an arguendo, that, Judge, if this was exigent circumstances, even if they had hot pursuit, it still would not have been justified because they retreated. He was essentially making a rhetorical argument. I think it was relatively effective advocacy in the moment, although the state interpreted it as a concession later on. And I think what he was trying to say is to kind of get to the point in my brief that this was not hot pursuit. This pursuit was lukewarm. This pursuit was ice cold. They retreated. They go out of the property. They don't return for 30 to 45 minutes. It's new cops. New law enforcement show up and go into the property. Officer Campbell was there, and Officer Gregory did go back into the property with the SRT team. But we're talking about a substantially new set of police. It's not a hot pursuit of a crime. So, not 1, not 2, but 3 unconstitutional incursions into this property. Any one of which would be fatal to the state's case. Any one of which would cause a Fourth Amendment violation. Any one of which would lead to suppression of all the evidence that was to be found later on. And it shouldn't be lost hopefully not on, surely not on this court, that everything that we're talking about here, as far as the shots fired, the alleged trespass at the other property, all this conduct was either uncharged or it was acquitted. Nobody was ever charged with a trespass at 18 Ward Hollow Pike, where this woman had complained of a burglary. The charge conduct of attempted murder, every single charge related to that gun, to violence, to an attempted murder, it was all acquitted. Only thing he was ever convicted of was the drugs that were found as a result of the manhunt for him, and then on his person at the end of the case. Okay, so nothing involving the actual gun, the firing of the gun, none of it was ever substantiated. He was acquitted of all of that. We would argue that he had a reasonable expectation of privacy on this land. Again, he was a resident and occupant of this property with his longtime girlfriend, Miss Hale. The record would reflect that. He was a constant daily user of this property. The vehicles that are on the property were vehicles that he was working on. He testified to that himself, and on the stand at trial. He used this property. Now, to be clear, this is a very large parcel of property. It's a mostly uninhabited piece of property. It's a very rough piece of property. I mean, just to be frank, when I went to investigate it, had to get basically a guided tour of this property before trial. Came back tick infested. This is a very rough piece of land. However, the portions of the land that was being used daily was extremely clear, and that's also the same portion of the land that the officers used and went past these vehicles, cleared the vehicles, used this homemade road. Essentially, the portion that they know is being used is the portion that they were incurring on. So the fact that there were fringes of the property or portions of the property that may or may not have qualified as open fields, those aren't the portions of the property we're even talking about in the first place.
I'm looking at the photograph that the state included in their brief, which I think they allege was Trial Exhibit 31, that says this is where the officers would have been standing. It looks like an open field. There's no structures there. Do you agree that's where the officers would have been standing?
It's at least close, Your Honor, to where they would have been standing. However, I would urge caution in looking at the photo and taking it at face value. That photo was taken years after the fact. The truth of the matter is, and part of the speedy trial issue in this case is, we're talking about 3 to 4 years after the fact, and with nobody to maintain this property. It was well overgrown by the time this photograph was.
Well, at the time of the event, was there any structures on this property? Were there houses?
Judge, yes, there were structures. There's a shed at the very front entrance, right as you come onto the property. It's a small rundown shed, and then there was the trailer, which I guess is probably not a permanent structure, but the trailer on the property where they were staying. And of course, between then.
Was that more like a camper? I thought I read it was a camper.
Yes, Your Honor.
It wasn't like a mobile home. It was a camper.
I think that's fair.
So, did the shot come from either that shed or the trailer, as you call it, or mobile home, or? No,
Your Honor. The shot came from over the Jeep, is what was testified to by the officer. So where the Jeep had driven to after it was parked, I think roughly near the shed at first. That's where the officers first encountered it. The Jeep fires up, goes over the hill. They follow it over on foot. Okay, later on. That's where the shot comes from, which I think kind of goes to the point, Your Honors, is that essentially this Jeep was in a section of the property that was being used. I mean, there were people there. Enough people to be described as a herd of elephants were standing right there using this property. This property was being used, right then, even at 10:30, 11 o'clock at night, when this occurs. So again, I don't want to beat it too hard, but it's, not one, not two, but 3 separate incursions, all 3 without a warrant, and none of the exceptions are going to apply. What the trial court found was hot pursuit in combination with the exigent circumstances of the shot. And again, while the standard is we're going to take the trial court's facts unless the evidence preponderates against them, but we're going to review their application of the law de novo. And I think what we have here is a situation where it's undisputed that the officers did not engage in hot pursuit. They left the property. They went back to the street, went back to their car, called for backup.
Well, that was after the shot was fired.
After the shot was fired, right? They call for backup. New cops come on, and they engage in that search along with Officer Gregory. Exigent circumstances alone, even if we grant that there were exigent circumstances from the shot, there has still to be, combination with something else. It's not just that. And in this case, what the trial court used and what the prosecution was using at the trial was the hot pursuit, but we can tell, the evidence preponderates, it's almost indisputed, other than the application of the law, that there was no hot pursuit. They hit the deck, understandably, nobody would ever fault them for that, but they hit the deck and they retreat. Completely understandable, but that's what they did. What they didn't do was chase after this herd of elephants to go find out who it was.
The hot pursuit, the way I understood it, was the hot pursuit that led them to the red Jeep whenever they first saw it. Is that where the hot pursuit was?
No, Your Honor, no, Your Honor. The alleged hot pursuit is directly after the shots fired.
After the shot.
Yeah, so shots fired, herd of elephants goes this way, officers hit the deck, they go that way. 30 to 45 minutes later, they come back onto the property with the SRT team. So that was not why they encountered the Jeep in the first place. That was at their encounter with the Jeep. And Judge, I believe I'm out of time for now. Come back for rebuttal. Thank you.
All right, thank you. All right, General Gross?
Good morning, Your Honors. May it please the court, Alan Groves on behalf of the state. This court should affirm the defendant's convictions because the trial court properly denied the defendant's suppression motion and the defendant's speedy trial claim is both waived and meritless. So I want to begin by talking about the suppression issues. And as defense counsel just mentioned in his brief, he identifies 3 separate searches that he's challenging on appeal.
Before you get too deep into that, I know at trial his lawyer at trial the state's attorney argued standing. Do we agree that this defendant has standing to attack
No,
this
Your
search?
Honor.
Okay.
No, that's our main argument against
Okay.
the initial search of the initial entry into the property. Our position is that the defendant lacks standing to challenge that initial search because he did not, in fact, live there. I know defense counsel has asserted otherwise in his brief and at oral argument today.
Well, yeah, what proof was in the record on that?
So in my brief on page 11 of my brief, I cite to the record where the defendant himself testified that he lived in DeKalb County. That was his own testimony. This was his girlfriend's property. The deed to the property, which is in the record, has her name on it. Now, at the suppression hearing, she testified, I think counsel had like a leading question where he asked her, does he live here with you? And she said yes. And then she followed up by saying, he's my boyfriend. And there was other testimony about how he would sometimes come over and work on cars that they just kind of left scattered across the property. So we do know that he often spent the night there. She was his girlfriend, and he did sometimes work on the property. But his own testimony was that he did not live there. He lived in DeKalb County, and he had another garage in a different county that he also worked out of. So because of that, Judge Easter, the defendant doesn't have standing for Fourth Amendment purposes to challenge the initial entry into the open fields on our property. Now, the Supreme Court has recognized in Minnesota versus Olson that if you're an overnight social guest, that you can have a privacy interest in the home that you're staying in. And there's been some other cases, like the Sixth Circuit case we mentioned, that have extended that to the curtilage surrounding the home. And the idea behind those cases is that, as all of us know, if you've ever spent the night somewhere at someone's house, it's just kind of reasonable that you do have some sort of privacy interest in where you're spending the night when you're in that other person's home. But the homeowner doesn't have a privacy interest in the open fields on their property. So just because it's private property doesn't mean it's necessarily constitutionally protected. The open fields doctrine is sort of an exception to this because it's not the home, and the curtilage is something that has to be closely attached to the home. So under the Fourth Amendment analysis, you have to look at this 10-acre piece of property. They're intruding into the very outer perimeter of it when they're stepping over this metal cable. Is that the curtilage of the home? This camper that's way back in the holler, or is it just an open field? That's the relevant inquiry for Fourth Amendment purposes. And to decide whether it's curtilage, you look at the done factors. So you look at proximity to the home, whether there's an enclosure, the nature of the use, and whether they've taken any steps to protect it from public view. The only one of those four factors that really applies here is there was this enclosure, because they did have this metal cable going across the front of the property, and there was some sort of black mesh fencing at the time. That's really the only factor, though, that weighs in the defendant's favor. There's no proximity to the camper. You can't even see the camper from the road. It's not clear there is even anyone living there.
So the cable just goes across like the entryway? I never could really grasp how that worked.
It seems like it. There's unfortunately no photographs from the time or body camera video. My understanding of reading the testimony was that there was some sort of a metal cable attached to posts running along the front of the property. But it's not exactly clear if it stretches the entire length of the property or just certain parts. And because we don't have the photographs, it's hard to know for sure. But so you don't have proximity. It's 10 acres. You can't see the camper. You maybe have the enclosure. There's no evidence of the nature of the use for this part of the property. When we're thinking about curtilage, we're usually thinking about, your backyard where your kids are playing or where you're grilling steaks and things like that, things that are closely associated with the home itself that you're using for domestic life. But here, all we really know is it's at the very front of the property. There's this beat down shed. Again, the only picture I think we have of that in the record, I think shed is a little generous for what we're calling it, but I mean, it's like a wooden structure that is kind of see-through. It's not really clear there's anything inside of it. It sort of looks like an abandoned structure of some kind, if that is what the shed is that I'm referring to in the picture. There's only, I think, one or two images of it in the record. But other than that, we're told there's not really a driveway that's paved. There's some sort of pull-off is how officers described it. And then there's no evidence that they've taken measures to protect it from public view. I mean, there's this black mesh fence that's maybe waist high, but I mean, anyone can see into the property, and there's not any kind of structure that would block public view. So for Fourth Amendment purposes, I think it's pretty clear that this area is the open fields. I mean, Judge Easter, you referenced the photograph that was taken by the defendant's own private investigator. And I acknowledge it's a couple years after this investigation, but there's no evidence or testimony that there were structures that were removed during that period of time while this case was pending. I don't think there's anything in the record to suggest that. So as far as we know, it did look fairly similar to what's in that photograph. The defendant did argue, both in the trial court and on appeal, that if this was not part of the curtilage for Fourth Amendment purposes, that it might constitute a possession under the Tennessee Constitution. And so I did want to address that briefly. But before I do that, and maybe I could have made this point a little bit more clear in my brief, but I think this court can actually just not address the issue of whether this part of the property would constitute a possession under the Tennessee Constitution. And this is why. This court could just write an opinion that says, even assuming that this part of the property would constitute a possession for purposes of the Tennessee Constitution, our courts have never extended this privacy interest of overnight social guests to possessions. I've never seen a case applying that doctrine to possessions. All the cases that I think the defendant cites are where the property owner is held to have a possession in real property because of some enclosure and daily use on the property. But I've never seen a case where someone that didn't live on the property was held to have a privacy interest in the outskirts of the land because of some enclosure. So I think the court could actually just avoid that issue altogether because Mr. Mabe was not the property owner and didn't have the same types of privacy interests that his girlfriend did. But if the court were to address it, the Supreme Court has been a little bit inconsistent in describing the level of protection that our Constitution provides. Sometimes it says it's identical in intent and purpose as the Fourth Amendment, And then you've got some of these older cases like Welch that say that it is a little bit more protective than the Fourth Amendment, and that the term possessions can encompass real property and not just personal effects. But importantly, they've limited it to land that is, see, I want to get the quote right, that's actually possessed or occupied. And often the court will say part of the property that's in daily use in connection with and as a necessary part of their use of the property, such as like farming operations. There's a lot of the daily use language. And even under that standard, again, there's no evidence of how the outskirts of this 10-acre piece of property are being actually used by either the girlfriend who lives there or Mr. Mabe.
Nothing in the record on that. Nobody addressed it at all.
No, and the defense counsel mentioned this morning that there is some testimony about the defendant working on cars on the property, but it's pretty clear from the officer's testimony that that initial intrusion into the property was not where the cars were located. I think they testified that you couldn't even see the cars when they initially walked over the cable and entered the property and they were approaching the Jeep. There were no cars visible at that time. You had to keep going further into the property down this hill before you could start seeing where all these cars were scattered throughout the property. So perhaps that part of the property would be evidence of like daily use, or a part that was actually possessed and occupied. But this, like the outer fringes of the 10 acres, all we really have is that there's some kind of pull off and maybe like a rundown shed. And I just don't think that's enough, even under our state constitution, if you were to reach the issue, to say that that's being actually used and occupied. But again, I think, and I also want to say that the Tennessee Supreme Court has said even our protection for possessions doesn't extend to wild wastelands, is I think the phrase that they use. So I guess that's sort of analogous to the open fields doctrine, but maybe a little bit narrower. The Supreme Court hasn't fleshed that out a whole lot. But I think the court can most simply address this by saying, even if we assume that these are possession, that this part of the property is a possession, Mr. Mabe doesn't have a privacy interest in that because he's only a social guest at this property that someone else owns. And we've never extended the privacy interest of a social guest to possessions. And if you think about it, that makes sense because, again, going back to our discussion earlier, when you're spending the night at someone's house, you might think, yeah, I have a privacy interest in this bedroom that I'm spending the night in, or in the person's home. The law enforcement's not just going to barge into this home without a warrant. But do you really have a privacy interest as a guest in someone's fenced-in, like, chicken coop, a quarter of a mile away from the home? That's not a reasonable expectation of privacy. So it would be pretty remarkable for this court to extend that doctrine for social guests to this context, and I'm not aware of any cases doing so. And then getting to the second and third searches, I do maintain that this was conceded in the trial court, and on page 13 of my brief, I quoted the transcript from the suppression hearing, where defense counsel says, volume 15, page 100, sure, after that, they had exigent circumstances. Period. And then again, a couple pages later, when a gunshot goes off, sure, there's hot pursuit, exigent circumstances, of course. And I don't read that to be assuming for the sake of argument. I think that's a pretty categorical concession. So our position is that this court should not address those issues because they were conceded below, and the defendant can't change positions now on appeal. And I understand defense counsel has changed and perhaps has a different strategy and wouldn't have given up that ground, but that's just not permitted under this court's precedents. And even if he could, as Judge Easter mentioned, when an officer is getting shot at, that's kind of a quintessential exigency. And I understand my friend to be really sort of making a police-created exigency argument that, well, it was only exigent circumstances because they were intruding into the property. But if the court agrees with us that they were lawfully present as we assert that they were, then the police created exigency doctrine doesn't come into play because they were in a place where they had the right to be. And they were just reacting to being shot at. And you have to look at it from the officer's perspective. And it's an objective analysis where you're looking at what a reasonable person would, how a reasonable person would react.
What about the fact that they left for 30, 40 minutes and then took off with other people? Does that make a difference?
No, Your Honor. And we've cited cases from this court's precedent upholding similar searches when there was a 30-minute delay or so. And I think the Sixth Circuit case that the defendant cites, there was like a 6-hour delay, O'Brien. So that's pretty distinguishable from the case we have here. And certainly we wouldn't want officers to, not be concerned for their own safety in making that hot pursuit. I think it's reasonable to still, have a brief retreat so that you can coordinate your response. But it was still a hot pursuit in that sense. We also do think that the hot pursuit exception would have allowed the initial entry into the property, as Judge Holloway was kind of getting at earlier. But if you agree with us on the standing question, you don't really need to reach that issue. So I'll just rely on my brief for that alternative argument. But I think our stronger and the most clear way to resolve the initial entry issue is that the defendant simply lacks standing, either under the Fourth Amendment or the Tennessee Constitution. I know the speedy trial claim wasn't addressed very fully today, but just briefly, I'll hit on that. We've argued in our brief that claim has been waived because, as far as I could tell, there is no transcript from the motion hearing where the trial court would have heard the speedy trial motion and made factual findings about the reasons for the delay and addressed each of these factors. And those factual findings are very important and critical to this court's appellate review. So we raised the waiver argument. The defendant did not file a reply brief responding to that, didn't move to supplement the record with the transcript. So this court's hands are really tied. It's hard to conduct meaningful appellate review when you don't have factual findings from the trial court. And
Is there anything in the record that we all know that was during COVID and we all lived through it and kind of know what delays that caused? Is there anything without that transcript that would even explain or show that some of those delays were COVID related?
yeah, and the court, if it finds the record sufficient, it could conduct a merits review, but you would need to presume that the missing transcript supports the trial court's ruling. And if you take that presumption and then you just look at what's in the record, it is clear that defense counsel, again, not Mr. Turkley, but a prior attorney, withdrew on the eve of trial at least one time. And so that was one reason for a delay. And below, the defendant conceded that was the case, and that weighed in the state's favor.
And that, as I recall, that was right before COVID hit. It was like late 2019 when the attorney withdrew.
Correct. August 2019. And then COVID hit in March 2020, and you've got shutdowns. And
When was the case tried?
the case was tried in April 2021.
Okay.
Yes.
A year after COVID.
Yes. And the trial court made it pretty clear that it was making it a top priority to try this case. But there's several agreed orders that are in the record continuing the trial, and there's just no evidence about why those continuances happened. They were styled as agreed orders, so I don't know if that. I presume the defendant agreed to those orders. There's no evidence to the contrary. And the most important factor, though, for speedy trial analysis is really prejudice. And here, as defense counsel mentioned, he was acquitted of quite a few of these charges. I think his attorney did a very good job below, was able to get many of those charges acquitted. So it's hard to see how you would be prejudiced when you've got a lot of the charges kicked. And he cites to several instances in the record where witnesses were not able to remember certain things, but there's never any explanation of why that mattered. And if you look at the examples he gives, a lot of them are kind of trivial and don't really go to the meat of the case. So if this court has no further questions, we ask this court to affirm the judgments below.
Thank you, Judge Brooks. Mr. Turkley, rebuttal?
Your Honors, I first want to touch again on the standing issue. I think that's important in this case. Essentially, there is conflicting testimony from Ms. Hale and Mr. Mabe as to whether or not he quote unquote lived there. But what I think Mr. Mabe was doing, and I think making the same kind of rhetorical mischaracterization as my friend is making, is they're conflating living there with ownership. Ownership isn't the issue. Living there, having a reasonable expectation of privacy is the issue. He is not just a house guest. It's a long time romantic relationship between these two people. That's what the record supports. He's on the property all the time, maintaining the property, basically living there. He owned the property in DeKalb County. Mr. Mabe wasn't answering that question for the purposes of Fourth Amendment. He was answering it just based off of his understanding of what, where he lived and what he owned.
Well, but didn't he testify that
He did.
he lived in DeKalb County?
He did testify to that, Judge. But as far as but the record shows, as far as where he actually spent his time, I mean, he can say he lives in one spot, but if he's there, if he's where he owns the property once a week, but he's where he doesn't own the property 6 times a week, is disingenuous to call him a social guest.
But he didn't testify to all those things you're saying, that he stayed there all the time and et cetera, et cetera.
Ms. Hale did. Ms. Hale did testify that he was there extremely frequently, working on these cards. It's not a one-off social guest situation. I just want to get back to the hot pursuit issue. Again, I can't stop pounding on it. Is just hot pursuit of what? Hot pursuit of who? They didn't know what they were looking for. They didn't know who they were looking for or why they were looking for him.
Well, when you get shot, does anybody really know who or what they're looking for other than some person who shot a weapon?
But what I'm saying, Your Honor, is they had no idea. They didn't have a description of this person. They didn't know male or female. I mean, I heard of elephants goes off in their directions. Are they going to clear this entire property of all living life until they stop where? Stop when? I would maintain they stopped when they retreated. It's no longer a hot pursuit at that point. It's a cold pursuit. There's also an argument that we didn't have to make because he was acquitted of everything related to the gun. The jury didn't even find that he was in possession, of the gun. But this entire exigency, as my friend pointed out, yes, it is a police-created exigency. They're searching for a trespasser, at least 2 properties down, at 10:30, 11 o'clock at night, and they get themselves shot at because of their behavior of not identifying themselves, of reaching down to a waistband, making a threatening movement, pointing it at this group of people and activating it. And the testimony is that the shot comes back instantaneously. It's a single shot. Single shot.
Before you spend all your rebuttal time, talk to us about the speedy trial issue and how that's not waived, or how we could possibly look at it without the transcript and the ruling of the trial court.
Your Honor, as far as I can tell, there was no on-the-record ruling on the speedy trial motion. I'm getting the impression it's probably done in chambers or informally. I've talked to the court reporter. I don't think there is a transcript of these proceedings. I understand his point, but what I would say on the speedy trial issue, Your Honors, is yes, there were several delays and continuances that were not necessarily caused by the state, but I would focus on the final remaining one in January 2021 before this case is ultimately tried in April of 2021. That case, on that particular continuance, that was caused by the state, and Your Honor, and I apologize, I don't have chapter and verse on that as to why they caused that, other than the fact that
what in the record shows us that
it was a COVID. I may have to supplement that and get that to you, Your Honor. But essentially, that was a COVID-related delay. But the issue, though, is that this particular court was very aggressive as far as in trying cases. We'd already tried a double murder case 8 months prior to this case. Exact same prosecutor, exact same judge, exact same courtroom. So the Judge Kane's one of my favorite judges in this entire state, but that as far as it delaying or causing the delay or declaring it to be by for COVID-related purposes, I think is weak based on the fact that particular courtroom had been open for some time. And again, and Judge Kane is, to his credit, aggressive about getting cases tried.
Did you try the case?
I did.
Okay.
I did.
So were you the lawyer that came in after the lawyer got out in August of 19?
No, Judge. I came in February of 21, 2 months before the trial.
Wow.
Yeah. So that was So I lived this case for 8 weeks, and it was.
You were appointed?
No, sir. I was retained. retain. But I think it's all my time. If there are no more questions,
All right, thank you, Counsel.
thank you.
All right, thank you. Good arguments, good briefs. We'll get this out to you as soon as we can.
Yeah, what a minute. One more.
Call the next case, please.
State of Tennessee versus Donovan Drennan.